All right, so Mr. Alessi, I'll hear you. I'll hear you, Mr. Alessi.
Thank you, Your Honor. The topic I would like to raise with Your Honor is the timing and nature and significance of the information that the defense has received from the firm Aperture. And Your Honor may recall there are two individuals on the witness list that we understand are to testify in this matter. First is Dr. Judson Welcher, and the second is Shannon Burgess.
And are they testifying in reverse order, though, than what you said?
My understanding is, Your Honor, yes.
Okay.
My understanding, Mr. Brennan has the best information, is that it's proposed that Mr. Burgess testifies first and Dr. Welcher testifies thereafter.
Okay.
So the Commonwealth has established in reports right up until, not established, they had stated in the reports of Aperture, particularly the slide presentation of Dr. Welcher, a trigger called 1162.2 that they have associated in the report of Dr. Welcher with a specific time. And that specific time that they have associated with that trigger is 12/31/38 to 12/31/43. And we have been assuming that information, and this is from best memory, but I believe it's slide 137 or so, where this statement is in the slide. And so we have proceeded with our defense. We have proceeded with the work that has been assigned to ARCA based upon that time period. On May 8th, not too long ago, Your Honor, we received an amended report of Shannon Burgess that pushes that time period. Now, I'm just going to get. So, although it was dated May 8th, we received it actually on May 11th. And in that report, Mr. Burgess states that he is making an amendment, and he is now stating that that infotainment trigger of 1162.2 is further back in time, and it is past 12/31/43.
Do you have the time?
I'm going to get the exact time, Your Honor. It is 12/32/16. And Your Honor may recall that the seconds, literally seconds, matter in the analysis of many factors. I won't go into them other than to say I went through and developed testimony with regard to the cross-examination of Mr. Whiffen. He had a timeline. He talked about much human volitional conduct. Suffice it to say that that information is literally, by seconds, determinative in some ways of various analyses. So we basically commissioned, if you will, ARCA to be looking at matters based upon the infotainment trigger 1162.2 of 12/31/38 to 12/31/43. As of May 11th, we received information that has changed that. Now, Your Honor, that is a Rule 14 violation, among other issues, but I wanted to start there. It's a Rule 14 violation. It's obviously, as I stated, an amendment of a report of a significant matter. And also, with regard to the defense's ability to provide a defense, we have to be able to evaluate that information in terms of our entire defense. And it's just not limited to ARCA. It's our entire defense. The other data point I want to get to, so the effect it's had, we still haven't even been able to evaluate entirely that. And I believe, Your Honor, based upon the information that I have, that this may have been a calculated matter by the Commonwealth, but even assuming it's not calculated, the effect is pronounced. So what I want to do, Your Honor, is to look at what the reason Mr. Burgess has given, which leads me to be very concerned about a calculation and a strategy calculation here. Mr. Burgess states in his own words that the reason why he is changed, that time is being changed, is to, quote, align the trigger with Mr. Whiffin's analysis. And Mr. Whiffin's analysis is based upon the extraction data from Mr. O'Keefe's phone. And I believe it's undisputed that the extraction from Mr. O'Keefe's phone occurred years ago. And the data from that has been extant, it's been available years ago. So to me, Your Honor, that basis can't be a proper basis at particularly this stage where we are approaching the end of the trial, just literally days before the testimony of Aperture, and we are in a very, very almost impossible, challenging situation. So, Your Honor, there are obviously, Your Honor knows the situation here. Our first request is that the May 8th report that we received on May 11th be not allowed, that it be not considered at all. As Your Honor knows, I don't like to use hyperbolic words, but the word has been used for us, against us, ambush, ambush, ambush. If there's ever an example of an ambush, this is it. And so, Your Honor, our request is that Your Honor find a Rule 14 violation, that Your Honor have the remedy be that the violation remedy be that this is not allowed, and that the Commonwealth proceed with its the information of Aperture that has been extant before the May 8th date of the report. Thank you.
All right. Do you have another option if that's not something that we do, right? Because the Commonwealth moved to exclude ACCA or have them go by their old report, right?
Right. And Your Honor, I'm going to answer your question, but with just the quick point that this is really much different than ARCA because two reasons. We are the defense, and ARCA is a rebuttal to the prosecution's case. That is much different than a prosecution changing its theory of the case at this time.
I understand that. I'm just asking if you have another option.
It's not what I am saying that I am proffering. I think the only remedy here is exclusion and a Rule 14 violation.
And you're not waiving that?
I'm not waiving that.
No, I'm not asking you to.
Your Honor.
Okay, a continuance for how long?
I could have a better answer perhaps to that question tomorrow. I haven't, given what's been going on, I haven't even had a chance to talk to ARCA at all.
All right, so tomorrow morning, let me know that. All right,
And Your Honor, I will do that, of course. And I will also say, without getting into an elaboration of it, we have to look at all the witnesses that we called. I'll give you an example. Mr. Whiffin. I had my whole cross-examination, not whole, but a significant part of my cross-examination of Mr. Whiffin based upon going through human volitional conduct off that phone that was after that 1162 trigger. And a lot of our defense in theory is based upon that's been in existence now for several months. And again, I go to the bottom line that the proffered reason in Mr. Burgess's report is to align with the data on Mr. O'Keefe's phone, and then that's been around for a long time. So that's my answer to Your Honor's question.
All right, thank you. Mr. Brennan.
Your Honor, this disclosure is not a Rule 14 violation. The Commonwealth, just like the defense is entitled, continues to work on their case and study their case as time goes on. This issue, the relevance of this issue, has been clear throughout the case, including my opening statement. And the issue is that clocks are different. There is a clock in a Lexus that runs on a different time than that of an iPhone. And if you recall in my opening statement, I talked about the fact that there are variances between those clocks. So instead of a moment that coincides happening at the precise second, sometimes there's a variance of time between the two. So the Lexus clock could be at a variance with an iPhone, but the event still could happen at the same time, given the clocks have different times. The defense provided a report by a person by the name of Mr. DeSorga, a noted expert witness who they've listed as a witness they may potentially call. Mr. DeSorga wrote a report, and in the report he suggested, based on his analysis, that Mr. O'Keefe's phone always ran late. That means if the text stream data, the black box data from the car, has an event at 12:31:38, and Mr. O'Keefe's last movements were 12:32:16, last user interaction 12:32:09, there is a variance between those times. We asked our expert to review their expert's report to see if he was accurate that the variance means that these times would never align. And that's what he did. He studied the data, he studied the waves, he studied the Lexus black box relative to the time. Doesn't change anything, doesn't change the data whatsoever, just adds to the time. What he learned, from his opinion, is that Mr. DeSorga was wrong. He used information from different phones, not recognizing the items that these timelines came from, and that his time estimates are wrong. So then he looked at the time of the event of the ignition, on and off, and he compared that to the Waze data. And when he did, he found that he could identify what the actual differential was. Instead of guessing that it was within the 30-second window, it was somewhere around 21 to 25 seconds. And that 7 minutes before the collision, Mr. O'Keefe's phone was 21 to 29 seconds ahead, which means you subtract that time, which puts it in the same variance that we've been arguing from the beginning, that the collision occurred at the same moments when Mr. O'Keefe last had user interaction, and that reconciles with the data. It does not change the text stream data or the black box information on the car whatsoever. It does not change ARCA's analysis whatsoever. We received this report on May 8th. I was surprised to receive it. I welcomed it. We turned it over on May 8th. There was no delay. It's been a week now the defense has had this information. And so this is not an attempt to align anything. While it may reconcile or identify that variance more closely, it doesn't change any data whatsoever. And so this is not a Rule 14 violation. The effort was in response to disclosures that we believe were wrong by the defense expert, and it is clarified and it is favorable for us. And so we should be able to use it.
Did you intend to use it in your case in chief, or only if this witness disorder? I don't remember reading that name, so I don't know how to pronounce it.
On my case in chief, because we now have this available data. As I said, this wasn't ambushed, it isn't something that we sat on. It was in response. Fortunately, we received their expert report, which caused us to focus more closely. And now that we've identified that variance, rather than having an open variance of 30 seconds, we should not be precluded from favorable information that has been provoked by a report by the defense.
Okay. Yes.
I'll do it quickly.
Okay.
Attorney Brennan has provided a lot of information, and he has accurately provided information, but he's got the time completely wrong and the significance respectfully completely wrong. I'm going to hit his 4 categories quickly. He said, he referenced Mr. DeSorbo, who is a defense witness. Two points about Mr. DeSorbo. First, Mr. DeSorbo provided his expert report within this reciprocal discovery deadline.
Okay.
And he provided that report months ago.
Okay.
So as I heard Attorney Brennan, he's saying the reason why we're getting something on May 8th is because Mr. Burgess supposedly is responding to that. That was months ago.
Okay.
The more apt point is, or an even more apt point is, Mr. DeSorbo was responding to the information of Aperture. It wasn't like Mr. DeSorbo was coming up. He was rebutting as defendants do. So, and it's Mr. DeSogra, D-I-S-O-G-R-A. Again, D-I-S-O-G-R-A. So that's an important point with regard to Mr. DeSogra. Now I want to go to Attorney Brennan's comment about clocks are different. I agree with Attorney Brennan on that. The shortcoming for Attorney Brennan's argument, however, is that the clocks are different concept has been in existence in this case for over 6 months. I can give you by memory Mr. Whiffin's report of December of 2024, where his report went into the different clocks and what their significance was. So that is almost 6 months ago, at least 5 months ago, the issue of different clocks has been in existence in this case. So therefore, the issue of different clocks dates back to then. But even more fatal for the Commonwealth's argument is that Mr. Burgess himself issued his report and talked about the difference in clocks. He already knew it. He already had it.
Did he testify to that last time? Did he testify?
Aperture was not part of the first trial.
All right, I thought Burgess was, no?
No, neither.
Okay.
No one from Aperture was.
I knew
Your Honor.
Aperture was, and I thought he may have been something. The name just sounded
Neither
familiar.
Burgess nor Welcher were
Okay.
part of the first trial. But they were retained. Aperture was retained, I believe, in October of 2024.
Okay.
And at best for the Commonwealth, Aperture had, and Mr. Burgess and Dr. Welcher had Mr. Whiffin's report that talked about the clock differences. So the clock differences cannot be, as the Commonwealth is proffering, some sort of new information that caused Aperture to provide a new report. This variance that Attorney Brennan talked about, it's called the clock drift. A more layperson's term is a variance of time. Mr. Burgess, in his original report months ago, has a whole section on clock drift. That's not a new concept for him. He's just changing the drift.
Okay, so what I'd like to do, because I want to address the other issue and I don't want to keep people here too long, can you wrap it up, Mr. Alessi, or is that?
In 60 seconds.
Okay.
Thank you, Your Honor. Your Honor, the last point I wanted to make, and I think I heard Attorney Brennan correctly, is he said he was surprised that he got this report dated May 8th. That's what I heard. So if the Commonwealth is surprised that they got it, that should mean, to me, Your Honor, be an outstanding, fetching reason to not allow it, because they're surprised to get it. And I can lastly say this, Your Honor, there's nobody that's more surprised to getting this than the defendant when we got it on May 11th.
Okay, thank you. The other issue about calling your expert on rebuttal, Mr. Brennan, based on the late disclosure of the ARCA materials. What's your argument on that?
I won't iterate the entire past, but Your Honor has found discovery violations. Your Honor has found that I want to phrase this properly, the efforts of the defense were improper. And inevitably, we've now received an extraordinary amount of discovery on the most important issue in this case, well beyond the discovery deadlines, without any excuse. And the court, understandably, has overruled government's objection and has stated that it is going to allow the defense to proffer 2 expert witnesses in a very complicated field, in an issue that is the heart of this case. If you're going to allow them to testify, despite the fact that we have not had adequate time to review, to prepare, and to address it. The Commonwealth has the burden of proof. The Commonwealth has an obligation to prove its case beyond a reasonable doubt. And this isn't simply late disclosure of some evidence. This is a massive amount of evidence of the most critical issue. And so we provided this information to Dr. Wexler. As you know, he was away. He did not get a report until maybe May 7th. He did not have a chance to look at it until May 9th. An extraordinary amount of work, effort, and expense has gone into preparing our case for the jury. He is still in the process of reviewing the materials. There are entirely new subject areas within this information, well beyond the simple 4 opinions that they gave at the beginning. There are studies, there are demonstrations, there are experiments. This requires not only review, but an analysis, testing, vetting, and then preparing testimony to address the claims made by the defense experts. Not to get into a battle of disparagement, but there was an order from this court to produce records.
Yes.
Did you receive a copy of that order?
Yes.
Who did you receive a copy of that
So
order?
we need Dr. Wolf to identify himself.
Please identify yourself for the record. Spell your last name.
Daniel Wolf, last name spelled W-O-L-F-E.
Who did you receive that order from?
I believe it was in an email forwarded from Miss Little.
Did you read it?
Yes.
Did you understand that there was a request for certain communications?
Yes.
Did you understand that you were supposed to turn those records over to the Superior Court?
Yes.
Did you turn records over to the Superior Court?
I provided a copy of that production notice to Miss Little.
Did you provide the records to the Superior Court?
I didn't directly email that to the court, no.
Did you indirectly email it to the court?
It was my understanding that it would be passed along to the court.
So you did not, pursuant to the order, provide the records to the Superior Court, did you?
Not directly to the court, no.
When you read the order, you understood what the order was requiring you to provide, correct?
Correct.
It was requiring you to provide all text messages.
Yes.
Did you provide all text messages?
I don't have any in my possession.
Did you look for any text messages that are not in your possession about this case?
Yes.
Okay, did you find any?
No, sir.
What did you do to look?
So I went through the phone that I presently have, and as I informed Ms. Little, last year I was under T-Mobile, was my carrier. Subsequent to that, I then switched to Verizon in, I believe it was November. So I made an effort to contact T-Mobile as well as get access to my T-Mobile account hub. Unfortunately, I was unable to get access to it or get any records prior to, or at least from my T-Mobile carrier. Then I went through my Verizon records that I have from 2025. That was, I could only go back 3 months, and I provided those records.
How about emails? You didn't change email carriers, did you?
No, sir.
Did you provide all your emails from when you first were contacted by the defense?
Yes, sir.
And you provided every one of those emails to who?
It would have been in the file that I put together for the production.
How many emails did you find between you and the defense?
I'd have to look at the order, but it was probably 6 to. Are you talking about present day or just from last year?
Anytime.
It was probably around a dozen or so.
Who did you correspond with by email on the defense?
Again, can you specify a time frame?
At any time. Who did you correspond with by email on the defense?
It would have been Mr. Jackson. Miss Little might have been on one of those emails. There might have been a couple other members. I don't remember off the top of my head.
Well, how about Ms. Reed?
I don't believe she was on any of those emails.
You've never emailed or been on a correspondence with her by email?
No, sir.
And how about Mr. Yannetti?
He may have been on one of the emails. I don't know as I sit here today.
You communicated by phone with the defense, didn't you?
Yes.
And that began as far back as March 2024?
After our report was issued, yes, in March.
Back in March of 2024, you spoke on the phone to Mr. Jackson
Yes, sir.
a number of times.
Yes, sir.
And as you spoke, you began to become familiar with him and his role in this case, didn't you?
We corresponded about, again, our expected testimony here at trial, yes.
I'll ask it again. Did you become familiar with him and his role in this case when you spoke to him?
I understood him to be the defense attorney on the case, yes.
Did you speak to Ms. Little by phone?
I don't believe so, no.
Did you speak to anybody?
Hold on 1 second, please. Thank you.
Did you speak, pardon me, did you speak to anybody other than Mr. Jackson about this case before the first trial?
I don't believe so, no.
Did you speak to anybody since then on
Yes.
the defense team? Who?
I believe Ms. Little and Mr. Alessi.
Okay, and how about Ms. Reed?
No, sir.
Did you ever have any conversations that weren't on a regular telephone? You have a Zoom?
Yes, we have had, I believe it was a Zoom or a Teams meeting. We've had a couple.
When was that?
That would have been more recently to go over some of the testing that we've done.
Did you ever have any Zoom meetings before the first trial?
No, sir.
Did you ever have any group conferences before the first trial?
I don't believe so, no.
Were you ever on the phone before the first trial in a conversation where you and Dr. Rentschler both were on the call?
There may have been an instance of that. I just don't recall.
Well, think back.
I don't recall.
At some point, you were contacted by Mr. Jackson and you decided or you learned that you may be part of this case as far as a witness?
Yes, sir.
When you learned you were part of this case, did you have contact with Mr. Jackson before you testified at the voir dire?
Did I have communications with him?
Yes.
Yes.
And in those communications, you spoke about your role?
I think we spoke about logistics and coordinating my arrival here for the voir dire and certainly the trial.
Well, when you spoke on March 20th, 2024, didn't you talk about more than coordination of logistics?
I'm sorry, what was the date?
March 20th, 2024?
So I believe that would have been the very first phone call that I had with Mr. Jackson.
Right. Was that more than about logistics?
Well, I think we were trying to figure out what should we do. I will note that this was a very abnormal situation for me, being involved in a federal investigation and then ultimately being called as a witness.
No.
Well, I'm trying to answer your question.
But you're not. Did you talk about more than logistics?
So, are you finished with your answer, Dr. Wolf, or are you still answering?
I was still trying to answer.
Go ahead, finish.
Thank you. So as I mentioned, again, the situation was abnormal. I didn't know if we could get involved. I didn't think Mr. Jackson knew we could get involved. In terms of a path forward, would we be able to do more work? Could we review additional material? How could we work together moving forward? There was a lot of unknowns, so there was a lot of uncertainty.
You done?
Yes, sir.
Did you talk about more than just logistics?
No, sir.
Did you talk about fees or structures?
I described to him our typical procedure when we intake a criminal defense case, right? There's typically a contract and retainer associated with that. So I described our normal procedure that takes place, yes.
So you talked about fees and scheduling and costs, what you charge.
I did talk about, yes, the contract and the retention letter.
When you talked about that contract, there was a discussion, wasn't there, about them hiring you, paying you, or retaining you?
Potentially, again, I prescribed our standard procedure.
Why was it you were talking about fees and schedules if you didn't think that you were potentially going to get hired?
Again, I prescribed our normal operating procedure. I had no idea how it was going to work moving forward, which is why ultimately, immediately after that phone call, I contacted the Department of Justice to get clarification on that.
We'll get to that, but I'm asking you specifically, why were you talking about fees and scheduling and being paid at that point?
Objection, Your Honor.
I'm going to allow it.
Again, because Mr. Jackson was interested, I believe, in calling us to testify at trial. So I explained to us the normal process. When a client reaches out and wants to engage us for trial testimony, that's typically again, the procedure that we prescribe at ARCA. So that's why I had that explanation to him.
So you were talking to him about details about potentially being hired. Isn't that fair to say?
I don't know about being hired. I think, again, him utilizing us in the trial as expert witnesses.
Well,
'Cause
what's the difference between him utilizing you and paying you for that utilization and him actually hiring you? What's the difference in your mind?
Well, I think there is a difference because ultimately, after I got clarification from the Department of Justice, they indicated that they could not, the defense that is, sign any type of contract. There could not be any type of agreement or retainer.
I'm not asking what you determined later. I'm talking about the conversation you had on March 20th, 2022, when you were speaking to Attorney Jackson. That's what I'm talking about, okay? Understand?
I don't know that I understand your question then.
Okay. When you had a conversation on March 20th, 2022 with Attorney Jackson, you discussed potentially being hired, paid, compensated by Attorney Jackson or the defense for this case, didn't you?
We did, like I said, I did explain to him our typical operating procedure when a client reaches out for trial testimony. I went over that with him, yes.
I'm not talking about a client. I'm talking about this client. Did you talk about them potentially hiring or retaining you for work in this case? That's the question I'm asking you. On March 20th, 2022, not the 22nd, not the 24th, March 20th, 2024, did you speak to Attorney Jackson about them potentially retaining or hiring you for this case?
I spoke to him like I speak to any other client that would be interested in calling us as a witness.
Okay. And so after you spoke to them, you spoke to representatives of the United States Attorney's Office, and you wrote an email back saying that you were going to put the conversation on hold. Is that fair to say?
Correct, until I got clarification from them.
And at some point it was on hold, right? At some point it resumed.
Yes.
When was that?
That would have been towards, I believe, the end of April.
The end of April. How was this relationship resumed? What was the contact, the conversation between you and anybody on the defense that resumed that relationship?
I think that I reached out to Mr. Jackson. Like I said, I think it looks like about a month had passed, and I had let him know that I had spoken to the DOJ and got clarification on moving forward.
Okay. So in April of 2024, you reached out to the defense and said that you had permission or a green light to move forward in the relationship with the defense in this case.
I had clarification from the Department of Justice, yes.
And that clarification allowed you then to work with the defense on this case.
Not work with, we could be called on the defense's behalf to testify. And for that matter, the Commonwealth could have also contacted us and utilized us at trial as well, if they should, please.
So when did you become an advocate for the defense?
Interesting.
Do you feel like you're an advocate for the defense?
No, sir.
Are you sure about that?
Sir, I'm on the science and the analysis that I've done. That's the side that I'm on.
You sure are. Because after that 424 call letting them know that the United States Attorney's Office gave permission for you to be called as a witness, you called them again that day, didn't you? Or they called you on the main line?
We may have exchanged a couple calls that day, yes.
Well, you did exchange a couple calls that day because we have at least some records. And when you called later that day after telling them that you had permission they could use you as witnesses, what did you talk about?
Do you have the records that I could take a look at just so I could see what you're referring
Do you
to?
remember having calls after you called Attorney Jackson and said you had the green light from the U.S. Attorney's Office? Do you remember having further calls that day?
I think we had a couple brief conversations, yes.
Okay. When you think about it, do you remember them, or are you just saying you think but you don't know?
I don't remember. I remember that there was one conversation, I believe in early May, that I had with Mr. Jackson, in which we engaged in a conversation where I gave him more information about my background, who ARCA was as a whole. I think we even got to talk a little bit about my family, my 4 kids and things of that nature, but it was a call about background and qualifications.
We're still back in April. You're moving ahead to May when you first started billing. I want to talk about back in April. Do you remember having conversations on April 24th with Mr. Jackson? Do you remember that?
I'm going to allow that.
I remember that there were conversations, yes. Specifically what they were to. I remember, I think they were brief, but I don't remember the specifics of them, no.
Well, in the brief conversation, what do you briefly remember about that brief conversation, Doctor?
Well, as I mentioned, I think I had finally received clarification from the DOJ, so I think I was letting him know that I had received that clarification.
Well, sir, you said that that was the first call. There were more than one call. There was then 2 calls to the main line. What did you discuss with him during those calls?
Well, to be honest with you, the call to the ARCA main line, I don't even know if I spoke with him. That's just to the main line, not to me directly. So he could have spoken to a receptionist who then tried to get a hold of me, right? So I don't know if that specific call to the main line was to me or someone else at ARCA.
Well, this is a new relationship, right? You were working on a contract with the federal government. You have only spoken to Mr. Jackson, according to you, twice. You don't remember the early conversations with them and what they were about?
I'm sorry, are we talking about now at the end of April
Yeah,
still?
we're still talking at April. April 24, 2024.
Yeah, as I just discussed with you, from what I recall, it was relaying to him the clarification that I got from the Department of Justice.
Right, but that doesn't take more than one call, does it?
I don't know. He may have been in court. There might have been some phone tag. I don't know, sir.
Well, there was a 9-minute call on April 24th, and then there's 2 calls to the ARCA main line, 3 minutes and 2 minutes. Do you remember any of those calls?
Again, when you say 3 minutes and 2 minutes, that makes it sound like, in all likelihood, he contacted the ARCA main line, got a hold of a receptionist or my project manager, and couldn't get a hold of me.
Are you just making that up, or that's what happened?
Sir, that is my best guess. I don't recall from a year ago.
We're not asking you to guess. I'm asking for your testimony.
That's what I recall, sir.
Do you recall him calling a secretary on the main line? That's what you recall?
He very well could have. I just don't know, sir.
But you're making a representation that you recall him using a secretary in the main line. I'm asking what you actually did and actually said. Do you remember speaking to Mr. Jackson, Mr. Jackson or anybody on the defense team after that initial call, back on April 24, 2024? Do you remember those 2 phone calls?
Objection, Your Honor.
So let's get an answer.
I don't remember those phone calls specifically, no, sir.
Next
Do you
question.
remember the phone call on April 30th, 2024? Do you remember that one?
I don't remember that call, sir.
Okay. Do you remember the call on May 1st, 2024?
I don't have the records in front of me, but was that a longer call by any chance?
It was 40 minutes long.
Okay.
Yep.
So then, yes, as I just described earlier, that would have been the call in which I went over with Mr. Jackson a little bit more about ARCA, my background, my education, qualification, the kind of casework that I do, things of that nature.
And did you discuss issues regarding this case?
No, sir.
So during the 40 minutes you spoke, you never discussed any of your findings that had already been made?
No, sir.
You had never discussed any of your testing in this case during that 40-minute conversation?
No, sir. And it was all laid out in the report that was issued in
I
February.
understand the report. I'm asking you, did you have any conversations about it with the defense?
No, sir.
So in that 40-minute conversation, you talked about your family, your pastimes, ARCA, but never, ever talked about this case?
Objection, Your Honor.
I'm going to allow it.
Correct.
You billed for that time, didn't you?
I believe that I kept track of that time, yes.
Okay. When you kept track of the time, did you submit that time and ultimately get money for that time?
Again, I routinely keep track of my time when I'm working on a project. So, yes, that time was kept track.
That's not what I'm asking you. Ultimately, that time that you kept track of, did you then submit it and get paid and compensated for that time? That's what I'm asking you.
Well, first off, I'm a salaried employee, so I don't get direct compensation when an invoice goes out. That old invoice, when it's sent, ultimately comes back to ARCA. That doesn't come back to Dan Wolf.
Okay. So in order to get paid for that, you would have had to submit that time through ARCA to then forward it, wouldn't you?
Objection, Your Honor.
Going to allow it. Is that true?
Yes. I keep track of my time so that my boss knows what I'm doing. Yes.
Okay.
Your Honor, can we approach, please?
Who asked me that?
Me, Your Honor.
Yes. Come on over.
Good morning, Ms. McCabe.
Good morning.
When was the last time you spoke with Carrie Roberts before your testimony today?
She called me last night.
What did y'all discuss?
She asked if my daughters were going to be staying home from school today because her daughter would possibly join them.
Did you discuss anything having to do with your testimony?
Not my testimony, no.
Did you discuss anything in that conversation with her prior testimony?
No.
Are you aware that she testified last week?
Yes.
Did you discuss anything after that, after she testified with her about her testimony?
No.
We know that through her testimony that you had a conversation with her the morning that she testified.
Yes.
Right? Did you discuss what you anticipated to be her testimony in that conversation before she testified?
No.
Have you and Ms. Roberts ever discussed anything about either one of your testimonies, either in the last proceeding or in anticipation of this proceeding?
No.
So for the entirety of the last year, even though you both went through a proceeding last year where you both testified under oath and it was highly, highly publicized, neither one of you, your good friend Carrie Roberts and you, have ever discussed either of your testimonies between that time and this time.
No, we've discussed the case, and we've discussed what happened that moment, the moments of the morning, but we have not discussed testimony.
Okay, so let's break that down for a second. I'm talking about, because the timing matters, I'm just asking at this point, if you'll bear with me, just the year from last year at a different proceeding to this year. You have discussed this case
Yes.
with Ms. Roberts.
Many times, yes.
And you've discussed the specifics of her memory, which would be reflected in her testimony, correct?
We talked about what happened that morning.
So you were talking about what she remembers happening that morning, correct?
No, what happened that morning.
Okay, so not to put too fine a point on it, Ms. McCabe, but if you ask me what I had for dinner last night, it's my memory of what I had for dinner last night. Would you agree with that?
I object.
Sustained.
Did you talk about her perception of what happened that morning during the last year?
We've talked about what has happened, yes.
Okay, so I'm trying to break it down between you and Ms. Roberts. You've discussed her perceptions and her memory of what happened, as well as, and separate and apart from, your memory and your perceptions, correct?
Correct.
So there have been circumstances in which you and Ms. Roberts have compared, by definition, what she remembers versus what you remember, correct?
I wouldn't say compare.
Now let's move to what would you say in terms of what you've discussed and why?
I would say that we've both talked about what we've discussed, but it wasn't like a comparison. We weren't comparing anything.
You've talked about what you discussed. What does that mean? Talked about your testimony?
No, we've discussed what happened that moment,
Right.
and in those moments. So, when I got a phone call, and that's my story. I got a phone call in the morning, and then Carrie can say, yeah, I got a phone call as well.
As you said, that's your story, correct?
Not my story. It's
Those
the
were
truth.
yours.
It's the truth.
Okay. So, for instance, when you got a phone call at 4:53 in the morning, Carrie Roberts wasn't there, correct?
Correct.
But you've discussed that with her.
Correct.
And you've told her what your perception of that, your memory of that phone call was, even though she was not recipient to and did not witness that phone call, correct?
I've told her about the phone call, correct.
As well as many other details that she was not privy to personally, correct?
Correct.
Conversations that you've had, for instance, conversations that you claim you've had with Miss Reed, correct?
Correct.
And you've told her what your perception is of those conversations, or your memory was or is of those conversations with Miss Reed, correct?
Which conversations with Miss
Any
Reed?
conversations, just anything that she wasn't privy to. You've discussed that with her.
Some things, yes,
Okay.
absolutely.
And conversely, Ms. McCabe, obviously, she's also discussed certain perceptions and memories that she has about this case, and the facts of this case, as she recalls them, that you were not necessarily privy to, correct?
Yes,
Things that may have taken place outside your presence, correct?
correct.
And you've talked about things, she's talked to you about things, now I'm getting myself confused. Y'all have talked about things that were outside of her perception and outside of your perception. And you've shared those with each other.
We've shared our experiences. We've become very close. We both lived through a traumatic experience.
How many times would you say you and Miss Roberts have discussed your individual perceptions of what you remember happening on the 28th or the 29th of January 2022? How many times?
It would be hard to put a number on that. We talk about, it's hard. We're bonded. We talk about the trauma that we relive every day. Karen called us for help, and we both answered the phone.
And that bonding is the glue that holds you two together. Is this case, correct?
Yes.
So that probably, by definition, is the foundation of many, many, many of your conversations. Wouldn't you agree?
We've grown into friends where we talk about many other things
Sure.
besides the case.
Sure, the movie you saw last weekend and what the kids are doing next week.
Yes, and yes, absolutely. We
Okay,
talk
so-
many different things, just like girlfriends do.
I'm just concerned with and asking you about the subject matter of this case and the details and the facts of this case. You two have probably talked hundreds of times, that's fair to say, about your individual perceptions, your respective perceptions of this case, correct?
This happened 3 years ago, and we've talked about it time and time again. This case has traumatized us, so
And
it's a
talking
huge
about-
part of our lives.
I'm sorry, I didn't mean to interrupt you.
Oh, it's, I'm sorry. I believe it just, I meant traumatized our lives.
Okay. It would be impossible for you two to have had so many conversations about your respective perceptions of the details of that day without that influencing the other person, correct? You've somehow been influenced by Miss Roberts' perceptions and her memories, correct?
I don't think I would say influenced.
Would you say that she's been influenced by your perceptions and your memories?
Objection.
Would you say that, Ms. McCabe?
No, I wouldn't.
Next question.
How many times have you met with anybody from the DA's office? And I'm just going to limit the time frame right now in anticipation of your appearance in this trial, yesterday and today.
I'd say roughly 4 or 5.
Can you give me a time frame when those 4 or 5 meetings were?
I don't have dates. I do remember at one point I met with Mr. Brennan. He was new to the case, so I went in and he introduced himself.
How long ago was that?
I
Weeks or months?
I can't give you a time frame. I'm sorry.
Do you think it was last summer?
No,
Do you think it was?
no, it was more recent.
Okay.
Yeah,
It
sorry.
wasn't in the fall of last year?
No,
It was in 2025 sometime?
I believe so.
You
Yes.
think it might have been February, January?
Again, I can't give you an exact. I'm sorry.
All right. I want to talk about the time frames of those conversations, then I'll ask you a little bit more about those conversations. So that was the first meeting that you had was with Mr. Brennan in anticipation of your testimony. What were the subsequent 4 meetings or so that you've had? With whom and approximately what time?
Okay, so another meeting with Mr. Brennan. Are you looking for who was
Sure.
there?
Who
All
else
right.
was there?
I mean, can I give you a general answer? I didn't write down like every meeting who was there, but
Of course.
generally, okay.
Was Mr. Lally there?
During 1 or 2 of the meetings, he was, yes.
Was Ms. McLaughlin there?
Yes.
Was there anybody else from the DA's office there?
The officer or trooper Tully was there at one. Trooper Buchanan was there at one. The witness advocates were there. And again, give or take the particular meeting.
Those are 2 meetings that you've talked about with Mr. Brennan and others. What about the 3rd meeting?
No, I'm sorry. I was lumping a few of them together.
Sure, understood.
I apologize.
How many meetings would you have? Let's just start there. How many meetings have you had with Mr. Brennan and either staff or colleagues?
So after the first initial meeting, I
Right.
would say, again, I didn't write them down. Off the top of my head, I can think of 2 or 3 more after that.
Okay.
Excuse me, first initial one.
So that's either 4 or 5 meetings with Mr. Brennan and some combination of his colleagues, Mr. Lally, Ms. McLaughlin perhaps, Mr. Nelson perhaps, the other employee of the DA's office, and Troopers Buchanan and Trooper Tully.
Correct.
You asked questions about at any of these meetings, I'm just going to lump them all together, any of these 5 meetings. By the way, when was the most recent?
Last night, I had a Zoom call in regards, I think the court asked them to.
Yes, I'm going to stop you right there.
Oh, okay.
I'm going to ask a different question, and if you don't
Okay.
mind, I'm just going to lead you through this question.
Okay.
You had a conversation last night. I'm not interested in that particular conversation. That
Okay.
was for a very specific purpose. I'm asking you about everything leading up to, but not including last night's conversation, okay?
Okay.
So let's just leave that one out. You've had, I think you mentioned either 4 or 5 other meetings with Mr. Brennan and some combination of his colleagues and or law enforcement.
Yeah, and I might have, in the 5, included that one from last night.
Okay, fair enough. Were you asked questions in those, we're just going to call them 4 meetings. Were you asked questions during those 4 meetings about your testimony at the first proceeding last year?
I reviewed I did review some of my testimony, yes.
In what format?
I
A
watched.
paper transcript or do
No, we just watched a little bit of it.
you watch your direct examination?
A little bit, yes.
Did you watch your cross-examination?
A little, yes.
Who cross-examined you?
You did,
That was me.
yes.
And did you watch the redirect or any part of it?
No.
Did you watch any part of any subsequent version of recross or additional questions that you were asked?
I don't believe so, no.
Was there a specific area that Mr. Brennan asked you to look at and review in terms of your direct or your cross-examination?
No.
Did you watch the entirety of the direct examination and the entirety of the cross-examination?
I do not believe so, no.
Were you questioned by Mr. Brennan following your review of that direct and cross-examination?
No.
So he didn't ask you any questions about any of your answers?
I don't, he showed me a dash cam and would ask me to point out who's this, who's that, a waterfall video, is this you, is this somebody? Those were the type of questions that he asked me.
What about any discussion about your demeanor and how you performed in the last proceeding? Objection.
Sustained.
I'll ask it a different way. What about your demeanor? I'm using probably a poor word, perform. How you came across, your demeanor in the last proceeding? Objection.
Sustained.
Did you discuss changing your demeanor in any way, shape, form, or fashion from the last trial the last proceeding to this trial, my mistake. From the last proceeding to this trial, was your demeanor ever discussed?
No, I was just told to slow down, answer the question, and, answer it to the best of my memory.
Was there any discussion about talking about your background, for instance, your family and your children and being a sports mom, as you talked about in your direct examination?
No, I believe I did that in the previous one as well.
Was there any discussion about crafting your testimony in any way to suggest a softer approach?
No.
Was there any discussion about how to develop your testimony from beginning to end?
I object.
Sustained.
Did Mr. Brennan ask you about, or let me ask it a different way, did Mr. Brennan take you through a series of questions, for instance, as almost a test run of questions that you might be asked either on direct examination or cross-examination?
No.
Did you practice your testimony with any member of the DA's office?
No.
Were there any sessions where you sat and was subjected to a cross-examination, like a fake cross-examination or a fake direct examination?
No, there
Anything
wasn't.
like that?
No.
What were the things that stand out in your mind? You said you had at least 4 meetings. How long was each meeting, by the way, ish?
The first meeting, I think, was fairly quick. It was just the introduction.
30 minutes, less than 30 minutes?
I don't want to give a time because I'm not sure,
Okay.
but it was fairly quick, yes.
Okay. What about the second meeting?
Again, I don't know specific meetings, but I can tell you that there was a longer one where I did watch some dash cam video, look at different pictures, things like that.
What kind of pictures did you look at? Other than the dash cam video?
The pictures of John's house.
Okay. The same photos that we saw today?
Yes.
How long in total would you say all of those meetings were? Just taking them all together.
I really can't give you an estimate. I think the first one was fairly quick. The second one, one of them was a little bit longer, maybe a couple hours.
Okay. Then the third one, was that also a couple hours, or was that one fairly quick?
That was fairly quick, yes.
So fair to say between 2, 3, 4 hours total meeting times?
Again, I'd have to probably go back and look at the date and the time. I really can't give you a specific amount of time. I apologize.
Did Trooper Tully or Trooper Buchanan ask you any questions during the course of any of these meetings?
Regarding the case, no, but we did briefly talk about how my kids were, how their kids were.
But they didn't ask you any questions about your testimony, about about the case, about your memories, about specific facts?
I do not believe so, no.
During any of these meetings, was anybody taking notes? Ms. McLaughlin, Mr. Lally, Mr. Brennan, any of the troopers?
No, I don't believe so.
So there was several hours worth of meetings with you, and nobody scribed any notes that you saw?
None that I saw, no.
And these meetings were not recorded?
I do not believe so, no.
Ms. McCabe, I'm going to ask you a series of questions about your family because I just want to make sure it's crystal clear who's who. You're married to Matt McCabe, correct?
Yes.
Your sister is Nicole Albert.
Yes.
Nicole is married to Brian Albert.
Yes.
It was Brian Albert's home that you were at, 34 Fairview, that you arrived at, where John's body was found, correct?
Yes.
The same home where that late night gathering was on January 28th, going into the morning of the 29th, correct?
Yes.
Would you consider yourself to be close with your sister Nicole and Brian?
Yes, very close.
Your families, it's not just you and Nicole, your whole families are close, correct?
Yes, we have a very close family.
How long have you known Brian Albert?
Since I was in kindergarten.
You consider him, even though he is not blood related to you, you consider him family?
Yes.
In addition to Brian and Nicole Albert, you're also very close with Chris and Julie Albert, correct?
Yes.
Just to be clear, and I'm going to do this slowly,
Okay.
Brian Albert's younger brother is Chris Albert, correct?
Yes.
Chris Albert is married to Julie Albert.
Yes.
You consider Chris and Julie family, even though there may not be a blood relation as well, correct?
Yes.
Chris Albert is a Canton Select Board member, is that right?
Now he is, yes.
And the Canton, that's in Canton? I said Select Board member. Did I mention Canton Select Board member?
It is in Canton,
Okay.
yes.
All right, obviously it's in Canton. The Canton Police Department reports to the Select Board, correct?
I'm not aware.
You're not aware of that echelon?
No.
Okay. You're aware that Brian Albert, your friend of, I'm not going to say how many years, but since kindergarten, was a Boston police officer.
Yes.
He had been a lifetime law enforcement officer for some 30 years before he retired recently, correct?
Yes.
He's a trained first responder, obviously.
Yes.
Brian Albert and Chris Albert have another brother named Kevin Albert, correct?
Yes.
Kevin Albert is a detective with a police department, correct?
Yes, I believe that's his title. I'm not
Which
100%.
Which police department is Kevin Albert associated with?
Canton.
And you've grown up in Canton your whole life, you indicated.
Yes.
Your entire family has grown up in Canton, correct?
Yes.
And you, Ms. McCabe, have 3 sisters. Nicole, we've talked about. You also have a sister named Shelley, is that right?
Michelle, yes.
Michelle? Mm-hmm. And Denise, who you mentioned in your direct examination.
Yes.
Nicole is also known by a nickname, is that right?
Yes.
What is Nicole's nickname within the family?
Coco.
Does Shelley also have a nickname? Well, I guess Shelley is the shortened
Shelley
name from
is-
Michelle, correct?
Yes.
What about Denise?
She's Dee Dee.
Dee Dee?
Yeah, like Deedeedee.
Your father lives close by in a neighboring town, correct?
Yes.
Don't tell me the town, but it's relatively close to Canton.
20 minutes, yes.
Okay. His name is Tom Weeks.
Yes.
There are, I'm not going to go through all of them right now because the family tree is getting large, but there are children, cousins, second cousins, nephews, aunts, uncles. There's a combination of familial relations within that set of folks that I just talked about, Chris and Brian and Nicole and you and Matt and the folks that we've just talked about.
Yes.
That family, that large family, celebrates holidays together, I'm guessing?
We don't typically, celebrate with Kevin and Chris, but my family does, yes.
Along with Brian, Albert, and Nicole?
Yes, of course.
Birthdays are celebrated within that family?
Yes.
Go on vacations together, I'm guessing?
Yes.
Gatherings like the one on the 28th?
Yes.
Special events?
Yes.
Spend weekends together?
Yes.
You mentioned a lot of sporting events. There's a lot of sporting events that y'all go to together.
Yes.
So it is very, very easy to see that it's an extremely close-knit family.
Yes.
And naturally, you're very protective of your family, as anybody would be.
Yes, I love my family.
You also said that you knew, and your words, liked Karen Reed, my client, on the 28th of January 2022, correct?
Yes.
But she very much is not family, correct?
Correct.
She certainly was not as important to you as your actual family, the Alberts, the McCabe's, the folks associated with them. Is that right?
Yes.
On January 28th, 2022, members of the Albert family and the McCabe family all went to a bar together, had drinks together that night. The Waterfall, we've heard a little bit about that, correct?
Correct.
Ultimately, you went back to your sister's house for the after party that we've heard so much about. That was at Brian Albert's house, is that right?
Yes.
You've been interviewed, I think you indicated multiple times. You didn't even give a number of how many times you've been interviewed by police in this case, is that right?
Yes.
Your family is connected to people at Boston Police Department. We've just talked about that. Brian Albert, is that right?
Well, Brian was a Boston police officer.
Right. So when I say connected, there is some familial or family or friendly connection to that police agency, Boston Police Department. It'd be Brian Albert in this case, correct?
The objection sustained.
There's also a connection to the Massachusetts State Police through your family, is that right?
Objection.
So define connection.
Julie and Chris Albert are very, very close to you, correct?
I'm close with Julie and Chris,
Right.
yes.
You're aware that Michael Proctor's sister, Courtney, is basically best friends with Julie.
No, I'm not aware of that. She's best friends with Julie's sister, Jillian.
Okay, so Courtney's best friends with Jillian, who's sisters to Julie,
Yes.
who's married to Chris, who's an Albert, who's the little brother of Brian Albert.
Yes.
Okay, and Canton Police Department. There's also some connections there as well, Kevin Albert being the most obvious of them.
Objection.
You know what? I'm going to allow that. Do you have a connection with the Canton Police Department?
Not with the department, but with Kevin Albert.
Right, who's a member of the department.
Yes, but my relationship's with him.
Understood. You've indicated that you've been interviewed by law enforcement agents associated with Massachusetts State, with Canton Police Department. That'd be Officer Lank.
Yes.
Can I
and
stop
Officer
you for a
Good.
second and see Counsel at sidebar, please?
Sure.
And then when Mr. McDermott comes back.
Thank you. The glass that you showed the jury yesterday, when you showed it to us yesterday, did it look any differently than when you recovered it from the ground where you were looking that morning?
No.
Did you have any information that that glass came from inside Fairview Road?
No.
Do you know where that glass came from?
I have no personal knowledge where that glass came from.
Thank you. I have no further questions.
Very briefly, Your Honor, you indicated that you were spitballing. Do to use your word, correct?
Correct.
Trying to figure out what happened.
Correct.
That's the job of an investigator, correct?
That is correct.
You
Yes,
don't
sir.
just take witnesses' words for things, do you?
That is correct.
You have to corroborate things.
Yes.
You have to look deeper,
Yes.
ask more questions,
Absolutely.
actually investigate.
That's why we're here today.
You don't rule out anything or anyone
We
right
didn't-
off the bat, correct?
Correct. and we
No
did not.
one is ruled out. Nothing is ruled out, correct?
That is correct,
You
yes.
follow where the evidence leads you, period, amen.
Absolutely.
You didn't seek, to separate the occupants at 34 Fairview, correct?
No,
You didn't interview Brian Albert formally, did you?
I did not. No.
You were asked by Mr. Brennan, did he ever end the conversation precipitously? Did he end it early or anything like that? He didn't end any interview because he wasn't interviewed, correct?
That is correct.
You didn't interview Brian Higgins.
That is correct.
You wouldn't interview Brian Higgins because he's your personal friend, correct?
Correct.
But you didn't have anybody else interview him either, did you?
Again, we're talking, I think we've gone over this and maybe you didn't understand. I didn't know Brian Higgins was at the house at that time.
Because you didn't ask anybody else who was at the house at that time.
I wasn't talking to anybody at that house, correct?
Might have been a good idea, wouldn't it?
Not at that time. We were there for one specific reason. We wanted to get to the hospital. So, no.
Might have been a
I
good
disagree.
idea to sit Mr. Albert down and say, there, you're shaking your head again. I'm not done with my question. Might have been a good idea, Mr. Gallagher, since you happen to be there, no sweat off your brow, to sit Mr. Albert down and say, by the way, I got a pen and a paper. Who was here last night, just before John O'Keefe was found dead on your lawn? Who was here? Might have been a good idea, correct?
So that was already done by Detective Sergeant Lank, and it was documented in his report of everybody of what Mr. Jackson is asking.
Then how did you two not know that Brian Higgins was there?
I don't know where.
At
I
34
mean, I'm confused. At what time?
Right.
At what time?
Exactly.
At what time?
When John O'Keefe arrived
Okay.
at 34 Fairview after midnight on January 29th, 2022.
So when I discovered Brian Higgins was there, wasn't until I read the report.
If you were standing in the house with Sergeant Blank, you just told these jurors knew that Brian Higgins and everybody else was there
He had obtained the names. He hadn't written the report yet.
and hadn't told his boss,
I don't recall.
even though you two went together to interview yet another witness?
That's correct. There was a very fast-moving scene and pace. That is correct.
While you were spitballing, you also didn't secure the camera footage that we've talked about, the Arlo footage.
Yes, that's correct.
You also didn't formally search the house, correct?
Absolutely
We
correct.
just talked about that. You didn't seek consent by Brian, by Brian Albert to search the house, correct?
That's correct.
You also didn't seek a search warrant. You talked about that, correct?
Correct.
You don't get punished or in trouble if you seek a search warrant and a judge who has to sign the search warrant. Normal citizens can't do that. It requires a judge's signature. You don't get in trouble or get spanked or get slapped or get fined if you seek a search warrant that is denied, correct?
In this particular situation, I would need to articulate facts, certain circumstances, and witness statements. What I had was nobody could put John O'Keefe in the house, including Miss Reed, and that we had a glass where they were coming from a bar, and I had 3 separate police officers, including myself, that had been in that house on 3 separate occasions and saw nothing amiss. I have a good faith obligation to present the truth to a judge. And if I don't, I can be found, end up on a Brady list or a Giglio list, as you know. And my credibility to testify in my career is basically over. So yes, you can get in trouble.
You're talking about lying in an affidavit, sir.
I'm talking about misleading.
Correct.
I would have to twist circumstances to have the right to search Brian Albert's house. We had no reason, and there's been no reason since.
How about this? There's a dead guy on the lawn that looked like he potentially could have been in a physical altercation. How about that? Might that be of some concern to go inside the house and see if there was a struggle that started in the house? Yes or not?
There's still no evidence to go into the house.
You have a guy that's out on the lawn with no coat on. You think the coat might be inside the house? That might be a reasonable assumption? Yes or no?
No.
You got a
Not-
guy outside with no shoe on. You think the shoe might be inside the house? That might be a reasonable assumption?
I never saw Mr. O'Keefe. I wasn't aware that he
Because you didn't
have his
seek
shoes.
to find out the details. Other people knew every single fact that I just suggested at the time you walked in the house, correct?
Objection.
Sustained.
The fact is you didn't seek a search warrant.
I wouldn't. Correct.
The fact is you never searched the house.
That's correct.
The fact is you never searched the basement.
That's correct.
The fact is you never searched the garage.
That's correct.
That's all I have, Your Honor.
Have you ever learned one fact that would have justified searching that house?
Not to this day.
Objection, Your Honor.
Sustained is to form, and you can put the glass in right now, Mr. Brennan.
Thank you. Move that into evidence, please.
Is it a 58? All right, Lieutenant, you're all set, sir.
Thank you.
Your next witness, Mr. Brennan?
I'd like to play clip 18, please.
Okay.
Thank you.
Your Honor, may we have a moment? Your Honor, may we approach? Ms. Little needs to see the court.